You're tuned back into Agriculture Today, and we are continuing our conversation with K-State and Washburn University School of Law professor Roger McEowen on the top 10 ag law developments of 2022. We left you on a bit of a cliffhanger there, but now our conversation continues with the two biggest ag law stories of 2022. Well, now we're on our top two, and I don't think this is going to be a surprise to anyone, Roger, unfortunately, but number two coming in is California's Proposition 12. Yeah,
that's an issue that's currently before the U.S. Supreme Court, and obviously, however the court decides this is going to be one of the big issues in agricultural law in 2023. But this is this California proposition where they passed this, and now they've got a law in California that says that you can't sell pork products in our state unless they are produced in a manner that we approve of in California. Well, that manner is not the way that pork is produced in the major pork-producing states such as Iowa, for example. And so you lose the California market unless you conform your business practices to what the California legislature has said. So what you have here is one state governing the ag practices in another state. And so that's the question before the Supreme Court is, can a state do that? To what extent can a state do that? What about retaliation? What's to prevent this? And the court really struggled with that in oral argument as to finding the line as to what's permissible state action and what's not permissible. It brings in Commerce Clause, Dormant Commerce Clause, kind of those legal terms that are out there. But this is a big issue because that California market is 13% of the national market, and you want to have access to that market. California doesn't produce pork. It's virtually zero. So these rules don't affect their producers. This is 100% extraterritorial effect. And so what California is doing has 100% effect outside their state borders. That's going to be a dicey issue for the court to deal with. I'm waiting to see what the opinion is going to be on that one, but that's a huge issue.
Absolutely. I think a lot of people are hanging on the edge of their seats for that ruling. And especially, like you said, the retaliation aspect of it all. If this snowballs, if this is allowed and it snowballs into something bigger, could be, huge and very detrimental for many ag industries.
Yeah, what's to say that Iowa couldn't come up with a law that says, well, you can't sell almonds in our state unless you handpick the almonds because we don't like the trees to be shaken. We like trees. We don't want the trees to be harmed. Where does this silliness end? And the Supreme Court's going to have to figure this out and give us some clear guidelines on this.
Absolutely. Thank goodness for them. I wouldn't want their job. Moving on to number one now. This is a huge story that we've been thinking about for a while now. But number one, the Major Questions Doctrine.
This was a U.S. Supreme Court opinion this past June, and this one is so significant. It's easily number one this past year because this really changes the whole administrative state of the federal government. We have a lot of rules that are in place as a result of administrative law, not because of anything that the Congress passed or a state legislature, if we're talking the state level. Now, this is federal level. But this involved an attempt by the EPA to basically change the manner of energy production in the United States away from fossil fuel into so-called renewable type production without Congress passing any type of law, without Congress saying this is what we're going to do in terms of what the rules are. And normally the administrative agency's only role when we have the Clean Air Act at issue here is to set rules under which certain businesses operate to comply with the law. You can't just change the manner of production by regulatory mandate, which was what happened under the Obama administration. That finally got to the court, and the court said, when we have an agency doing something that involves a policy decision on a national scale, that invokes what's known as the Major Questions Doctrine, and they can't do that. That is a matter for elected politicians to either stand on or get voted out of office on, not unelected bureaucrats. So it is an opinion of monumental importance in terms of the administrative state in this country, and it really pares it back to give kind of a sense of the founders that, look, it's the elected bodies that make these major policy decisions that affect the whole country, not unelected bureaucrats.
Absolutely. Yeah, it's not even just a question of the EPA, but other bodies as well that lie within our government and things like that, like you mentioned. And it's a matter of you uphold the policies put in place. You don't create them, like you said.
That's right. Yeah, you can set forth the boundaries within which certain businesses and economic conduct takes place consistent with the purpose of the law. You can't override what that purpose is by saying in this instance, we're going to shift the entire manner of energy production in the country. Well, the Congress can do that, but an administrative agency can't, and the court set it straight.
Well, Roger, I know you talked about all of these top 10 cases for 2022 in a blog post recently. So if listeners want to read that, where can they do that at?
Well, there are two ways to do that. One is to go to my website, which is washburnlaw.edu/WALTR, or the K-State Ag Econ Ag Manager website.
Well, I'll link to both of those in the show notes of today's program, which as always can be found on agtoday.net. But Roger, as always, thank you so much for your time. It's always wonderful to have you in studio.
Thank you, Samantha.
Absolutely. Once again, that was K-State and Washburn University School of Law professor Roger McEowen joining us for this week's Ag Law Update, focusing on the top 10 stories of ag law developments for 2022.